service, I do want to address Exhibit 6, which was previously received by the court. This is the 6-minute squad cam and audio footage from Officer Phillips. As I advised last week, after I went back into chambers to review that, I did note what Mr. Brooks had said. I may have been a little bit off on the language in terms of what Ms. Patterson is heard saying, but it's a pretty clear reference to one of the incidents that is the subject of a prohibition by this court related to other acts. And I indicated I was inclined to strike that exhibit, and so advise the jury, but I would give the parties an opportunity if they had any arguments on that to address that this morning. So since the state offered it and there is that violation, I'll turn to the state.
Thank you, Your Honor. First, I do offer my apologies to the court and to Mr. Brooks, because the previous occasions where we had watched that video, we did not catch that. I think the record will speak for itself, but there was a lot going on in that video. As you had mentioned previously, the officer's radio was talking. You can hear the dispatcher, you can hear other officers, and you can hear some people talking in the distance as well. So the exhibit can stand as is. We could redact just about a 2 or 3 second audio from that recording where those words are removed, and I listened to it several times. If we did that, it would not be that obvious, so that the exhibit could stand in place. If we strike the exhibit, or we strike words from the exhibit, we may be calling undue attention to something that was very vanilla to this jury that they really wouldn't have thought twice about. We would offer to redact that portion if appropriate, but it may also be appropriate just to leave it stand as is. And should they ever ask to see that exhibit again, we would prevent that from being played a second time.
Thank you. Mr. Brooks, do you have a position on this?
Yeah, I mean, it's obvious to me. I can only hear out of one ear, and I was able to hear clearly what was said. With all due respect, Your Honor, you made a ruling about this previously, in ample enough time before the trial even started. You made the ruling. I see no reason why the exhibit should be admitted into evidence. From my perspective, it's clearly obvious what was being referenced. I mean, if she was able to give any type of statement at that time to the officer, then obviously she wasn't at that time on that date, on the 21st. She would clearly be referencing some other incident. Hence the reason why we argue all the time in this, that, and the third. It was clear to me what was being referenced, and because of the ruling, because of the implication in that statement, I believe the exhibit should be striked altogether.
Thank you for your position, Mr. Brooks. And the reason why last week I said I'm inclined to strike it, but I wanted to give the parties an opportunity to review it over the weekend is, in some respects, because of what the state just said. There's information on that clip, at least from Ms. Patterson, that I didn't know if you wanted to come in or not, about nothing happened here, right? Those types of statements. So that's why I give the parties a chance to look it over and then come back to court and tell me what they want to do. So your position has been made clear. You believe it should be struck or stricken, as we say. And I agree with you, Mr. Brooks. This court gave their prior ruling related to other acts, and the state had an obligation to abide by that ruling. While I have options available to me, meaning I could redact it if the jury wants to hear it later on, my concern with redaction is it may possibly highlight that portion. We don't know whether any one of these jurors heard it and made a note about it. And that's certainly not something I'm going to ask them to reveal. And because of the violation, and even though there's other things going on, even though I could redact, I am going to strike this exhibit and so advise the jury. As far as advising the jury, I simply want to tell them the following when they come into court today. Is previously the court received Exhibit 6 during the testimony of Officer Phillips. The jury is hereby advised that the court has stricken this exhibit, and the jury is to disregard anything it may have heard regarding what was on that exhibit. Any objection to that language from the state?
No.
How about from you, Mr. Brooks?
No.
All right, you know that that's not my responsibility to address what happened other than how it impacts this trial, which is why I wanted to have a record. If there's anything you believe should be in the record from you regarding that, then you should turn that in. Okay? All right, I didn't have anything else on my list of things. I don't know if the state does or Mr. Brooks, so I will ask the state first. If there's anything you believe I should address prior to the jury coming things, I don't know if the state does or Mr. Brooks, so I will ask the state. For now, Officer Phillips will remain under the state subpoena along with Erica Patterson and Detective Guth. We can take issues up with that either, maybe closer to the lunch hour or when we come back, or even at the end of the day, but I would like to bring the jury out. But of course, Mr. Brooks, I need to turn to you first and see if there's any issues you believe the court should address.
Very briefly, I just want to state this for the record that I would like to issue the court an apology from me in regards to my actions last week during the trial. I just want the court to understand it's very emotional right now, not only for just the whole situation of the trial, the families here that have to go through, everything that's going to be involved with the trial, but also my family as well and myself is very, very emotional. But not to excuse my actions, I should carry myself with better respect than that. I wasn't raised that way, and I owe you, Your Honor, and the court an apology, and I'm going to stand up as a man and tell the whole court and you, Your Honor, that I apologize to the bailiffs, that I apologize for my actions. Like I said, that's not how I was raised. I come from a Christian background. My mother did not raise me that way. She did not raise me, to act out of frustration and irritation and anger. And I just wanted everybody to know that I apologize for my actions. And I'm going to try my best to, whatever happens, to everybody here. I just wanted y'all to know that.
Thank you, Mr. Brooks. I do appreciate that. Understandably so. This is an emotional experience, I think, for everyone involved. And I appreciate that you, upon reflection, have realized that courtesy and decorum are an important part of a court proceeding. I know that despite you being emotional at times and not being an attorney, you certainly, you're clearly paying attention. You've made some very salient points throughout the last few days. I think you're settling in quite well, and we're going to keep this trial going. I know you said earlier, and I just want to make a record of this because it's really important that I do this, sir. You've mentioned repeatedly about your hearing. I know you don't have the headphones on now. We'll give them to you just based on what I've this morning and how you've responded to things that have been said. I think you're hearing us, but if we haven't made the headphones available, we got to make sure we do that every single day so that if you need them. But I do appreciate everything that you've said, And I know we have Detective Casey, who will bring up momentarily for your cross-examination, just so everyone is aware. It's my practice when there's a second day to also put the witness under oath again. So he'll at least be sitting up there when the jury comes in.